Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. Good afternoon, everybody. My name is Katie Jones with ADR Services, Inc., and it is my pleasure to introduce this afternoon's program entitled Surprise, How to Avoid Employment Mediation Rabbit Holes. So to start us off, I will introduce Lynne Bassis, who has pulled this panel together for us this afternoon. Lynne is a leading mediator with over 25 years of experience specializing in employment law. Before joining ADR Services, Inc., she mediated for the California Civil Rights Department and offered basic and advanced mediation training through the LA County Bar Association. She served as director of the Disability Mediation Center, a clinic on the campus of Loyola Law School, where she instructed law students in the art of mediating disability cases. Lynne sets the table for success by engaging in and tailoring each mediation to the specific needs of each case. So thank you for joining us today, Lynne. Next, we have Young Ryu. Young represents employees only. He has represented hundreds, if not thousands, of those who are in need in state and federal courts by co-counseling with many other attorneys and has obtained judgments with a total economic value over tens of millions of dollars. Young has also been appointed as class counsel in numerous state and federal class action cases, representing thousands of consumers and employees across the United States of America. Thanks so much for joining us today, Young. And bringing us the defense perspective, we have Jackie Harding. Jackie is known by firm clients as the go-to defense attorney for all things about employment law. Jackie's law practice focuses on numerous aspects of labor and employment law. She litigates in state and federal courts and before agencies, including the Equal Employment Opportunity Commission, the California Civil Rights Department, the Department of Labor, and the California Labor Commissioner. Jackie also advises numerous global employers on California employment law. And prior to joining Wilson-Elser, Jackie worked in the Labor Relations Department at the Walt Disney Company, an American multinational diversified mass media company. So thanks so much for joining us today, Jackie. And without any further ado, I will hand it over to Lynne to introduce the program that we will be enjoying today.
Thank you, Katie, and thank you for all of your help in getting this program started and finished, hopefully. So I would like to welcome everybody who's with us today to our program, Surprise, How to Avoid Employment Mediation Rabbit Holes. You'll hear today from Young Ryu, a very experienced plaintiff's counsel. You'll hear from an experienced defense counsel, Jackie Harding, and moi, experienced mediator. We hope to spark some ideas in your minds about how to respond to and adjust to various rabbit holes that you might face. We have taken our scenarios from our own personal experiences, as well as that of our colleagues, and for certain circumstances, we prepared some for today's program. We're not going to identify anybody by name, be it attorneys, law firms, or judges, or anybody else. We will answer questions, as Katie said, time permitting. These are the topics on your screen that you're going to see us address throughout our program. So Jackie, would you start us off on a pretty interesting surprise, no authority to negotiate?
I sure will. Thank you very much, Lynne.
Slides, please, Katie. Thank you.
This mediation took place a couple of years ago. We were defending a sexual harassment case against a very well-known plaintiff's firm that routinely gets 7-figure awards at trial. And I had been working for months and months in the litigation with the top senior associate And we came to recognize that each side had its difficulties and we really needed to just settle the case if possible. So we decided to engage the services of a mediator with the understanding that we'll both come in with our best numbers and we'll try to work for our client's benefit by getting the case settled. Well, on the day of mediation, I was in the defense room with our clients, and the plaintiff's attorney had not arrived at the appointed time. So the mediator decided to just meet with us first, talk to us about our evidence and what we were willing to settle for and so forth. And we were waiting, and about 30 minutes later, the plaintiff's attorney shows up. The plaintiff's attorney was not, in fact, the senior associate I had been working with, but it was someone who was brand new to the law field. In fact, a new attorney. And so the mediator went into the room, tried to talk to him about the case and so forth. The attorney didn't seem to know much. At the end of their conversation, the plaintiff's attorney said, "And by the way, I'm here to deliver a message that we will take $2 million and nothing less." Well, the mediator was surprised and wanted to talk a little bit more and see whether there was any room for negotiating. The associate repeated himself, "Nope, I'm here for only one thing, to demand $2 million. Well, that's kind of stopped the conversation in that room, and the mediator came back to the defense room and delivered the message. We weren't prepared to do that, and we weren't going to just turn over $2 million. We weren't even going to negotiate from that perspective. So in short, the mediation had to end early because it simply didn't make any sense to us. And we also felt that we had a pretty good chance of prevailing on some other issues. So specifically, we were going to file a summary adjudication, and eventually we did so. And eventually we were able to get the case settled for much less because our summary adjudication was granted. What this did, though, however, in my mind, was that it emphasized the point that this new associate, had been just cruelly, in my opinion, used here to be just a messenger. That's not the job of a new associate. And my understanding is that he did leave the firm within weeks thereafter. It was also a waste of time. There was no need to even go into mediation if both sides weren't going to make an earnest effort to settle the matter. So obviously we were pretty upset about that. I sent a message via the mediator expressing my ire, and I hope the mediator communicated that to the firm, the plaintiff's firm. And as a result, I also now have a practice of talking to mediators just before mediation to assure myself that we will have someone in the other room who can negotiate and has the authority to settle cases. Otherwise, I shy away from a mediation if I can't get that kind of information and guarantee. But in the long run, it was a good effort because we did manage to settle the case after a lot of litigation. And it was a settlement that was pretty close to what we were willing to settle the case many months before in mediation.
Thoughts about that?
Yeah, first of all, I think this is not something any plaintiff's attorney should do because it's not only a complete waste of time, but also your share of the mediation fee. And never good for the, like Jackie already pointed out, never good for the junior attorney's career, because it's all about reputation, and we all know how these towns are so small. If there are two possible scenarios that I might just chip in, what happened here could have been the number one, the plaintiff's firm was just horribly unprepared in fact-finding effort, and just tries to muscle in during the mediation process to save their face in front of their client. Then the client obviously has a good reason to suspect whether the due diligence, discovery, and fact-finding was done by his lawyers, which could be an unethical situation. The other possible scenario might be the court ordered mediation. We all know that the court cannot order the mediation, but the judges do that all the time. And because I don't want to, and then that plaintiff's attorney might have a feeling that I cannot go to the mediation at this point, but it is court ordered, we just have to finish it to report something at the post-mediation status conference. Then they just came up and say 2 million is what we are going for, basically declaring it, and then just leave. That could be another possible scenario. Neither way, it doesn't seem like a good picture.
Unfortunately, I too, as a mediator, have seen this happen all too frequently. And it happened before we pivoted to doing remote mediations in the COVID period. It's happened in in-person situations. And as both Young and Jackie have said, we have a puppeteer that's off scene, that's pulling the associate in one direction or another. And the problem is that we don't have the input of that outside authority. We don't have that influence. We don't have that person's involvement in the process, what that person can offer, his tone of voice, his insights, his words, actually. All of that makes a difference in mediation, and it does have an impact. So typically what would happen, and what has happened, is the associate would look to me for guidance. And my first question, of course, is I'd want to inquire, is this the pattern in the firm? Is this an unforeseen emergency that's arisen? What's going on here? And whatever I'd be told, eventually the associate is looking to me for guidance, what can and should be done. So I step into my role as trainer, which I've done many, many times over the years. And I advise and have advised the associate that it's a missed opportunity for the client. The client doesn't have an opportunity to participate in a mediation, to hear other evidence, information that might be elicited, to witness the financial monetary negotiation. And that's a missed opportunity for the client. Secondly, as Jackie has indicated, it's a missed opportunity for that associate. We all know that developing negotiation skills are very important throughout one's career, not just in mediation, but throughout one's career in mediation, in litigation, in life. So I do what Young has indicated, and what Jackie has indicated, that I ask for the identities and the titles of who's coming up, and really make sure that those people are planning to be engaged once the day comes. This seems to me that one surprise that we ought to be able to eliminate based on the due diligence of the mediator and reaching out to counsel before the day of mediation. So I'd like to share with our audience, next slide, please, Katie, a variation on the theme. Late in the day, after a partner who had been representing the plaintiff all day long with the associate observing silently, the partner was called away on an emergency. And the case was settled, all but settled, I should say, almost inked. The associate, however, had a different opinion and decided that no, the case was not over. That additional $5,000 was necessary in order to settle the case, and doubled down on that demand, indicating that without the additional $5,000, there would be no settlement. So what happened in the defense room was the defense took this as, an associate trying to make a name for him or herself. The defense folks decided not to blow up the settlement over $5,000. Obviously, $5,000 in a different type of case could make or break a case. This was a very large case, and in this particular situation, for a host of reasons, defense counsel decided to move forward and settle the case, paying the additional $5,000. So I know my co-panelists have a different view on this. And Jackie, why don't you share what your thoughts are about it, if you would?
Sure, Lynn. I'm not sure whether this is a small firm or, with one or two associates and a partner, or if it's a large firm. But for associates in large firms, this action is really a career killer. You never undo or add to something that a partner has already negotiated and has said, this is it, let's move forward. There has to be a basis of trust in the firm, trust in fellow partners, also trust in our associates. When we do something and we say it's done, that there are no alterations, no changes made after the fact. So this went well in terms of it got settled. But think of the situation where it doesn't get settled, where it blows up completely. That associate who did that would never have any credibility with his firm. And I know that, partners talk, and it becomes very clear who you want to go with you to a mediation or who you even want to work with on a particular case. And partners are not willing to take a chance on someone who would do something like that.
Young, what's your thought on that situation?
Yeah, this is really a bizarre, least to say, situation, perfectly dragging everybody down to rabbit hole. I mean, if it's a $3 million settlement, for example, and you want to add $5,000 on top of that, bizarre. If it's a, let's say, $35,000 settlement, and you want to add $5,000, that's going to be a deal breaker right there. Because $35,000 settlement, obviously, $5,000 increase is a big deal. So I guess, although I was never been a defense counsel, I would go ahead and ask the mediator to reach out to this partner to see what's going on. I guess that might clarify the situation a little further.
Okay, good points, both of yours. So we're going to move on to the next slide now, and it's a PAGA surprise. Young, would you give us insights on this PAGA-only situation that you faced?
Sure thing. So when the collective action come in, this is a loss to wage in our case, by the way. You file the PAGA notice with the LWDA. And then because PAGA notice has to be communicated to the defendant, the defense counsel show up telling you, and this happens all the time. I know you guys will see what I mean. Hey, by the way, there is a very solid arbitration agreement. You guys cannot proceed this as a class action. Setting aside all the talk about the Viking Cruise case, because there is an arbitration agreement, we filed it as a PAGA-only case. And then the defense approaches, let's go ahead and see if we can mediate the case. That's fine. Let's just do 30% sampling for the purpose of the mediation only, and then we will analyze your data. Fine. They produce it. We went to mediation. And in the mediation, they are suggesting certain numbers. And in the end of the day, when we have the ballpark figure, mediator all of a sudden tell you, would you, Young, want to include the class allegations and then make a global settlement? Which is a surprising moment because it was the defense counsel who was adamant about, Young, you cannot allege class case because then I'm going to take the case immediately down to arbitration rabbit hole. So surprising, but of course, based on that suggestion from the other side, as a plaintiff's counsel, you will have a dilemma because they will raise the money for the settlement. Now, the problem you're facing there is obviously, did you do the due diligence discovery? There was no discovery done on the class allegations for the purpose of the mediation because it is a PAGA-only case. And therefore, the time cards and payroll records you obtained for the purpose of the mediation only covers PAGA statute limitation of 1 year. Just by analyzing 1 year of data without obtaining any further, you cannot seriously submit the declaration with a full CULA analysis requirement. It cannot be done. Nevertheless, the mediator will tell you, hey, extrapolate the data, go ahead and settle this matter on a global basis, and there's more money on the table. The judges see through this kind of efforts right through. All the more reason why you want to have a solid motion for preliminary approval paper. But at the same time, you have a dilemma of whether you, being the class counsel, now the class claim and PAGA, of course, too, whether you are doing the fiduciary duties as a class counsel to exercise duty of due diligence, prioritizing class's interest. I've done it several times, actually, as a matter of fact. The safety net in doing so that I came up with is that you want to be specific about the conditional nature of this settlement based on the additional data to be produced by the defendant, and always place the escalation clause in the settlement agreement. Those are the possible way to repair or creating a safety net for a situation like this.
Great. Katie, next slide, if you would. So I wanted to make a few comments about the KULAR analysis to which Young referred. KULAR versus Foot Locker Retail. That was a situation in which the lower court approved a class action settlement coming out of a mediation. And a couple of the class members objected to that settlement, stating very adamantly that there had been absolutely no discovery done on the rest meal break claim. There had been no declarations. There had been no inquiry into the frequency of the missed meal and rest break claims, nor had there been any inquiry into the reasons for the missed meal and rest break claims. So what ended up happening was the court said, there wasn't adequate evidence before it. Excuse me, and the Court of Appeal ended up saying there wasn't adequate evidence before it to approve the class, the rest break, meal rest break element, and sent the case back down to the trial court to comply with the guidance that's required. The evidence code sections that are stated on the screen were looked at and recited by the Court of Appeal. So as you probably know, the court has an independent duty to assess the fairness, reasonableness, and adequacy of the settlement based on the evidence before it. And in this case, the court said, the evidence isn't here. So the problem was that the statements made or discussion had during the mediation may have very well relied upon or focused on the meal and rest break claim. Unfortunately, that evidence was not before the court. And properly, the court stated it cannot rely on statements or writings that were made for the purpose of, in the course of, or pursuant to the confidentiality statute. So in this particular case, that information was not admissible, and that's why the case was sent back to the lower court. So what could the litigants have submitted to the judge? They could have submitted, as Young said, time records, payroll records, and things like that. And most likely that would have been adequate to support the actual mediation settlement agreement. So the outcome of this is, or the lesson taken is just to be sure that the settlement ends up before the court with the proper documentation. Jackie, I think we're about to take off on a new topic, but did you have something to share in terms of your thoughts on this?
Yes, with respect to the defense position and perspective, I think everybody should understand that when we get a class action PAGA matter or PAGA matter, the first, especially if it's a large employer, the first thing we're asked to do is really see not only if there is any truth to the immediate allegations in the complaint, but also any other wage and hour issues that the company is not compliant with. Because large employers are obviously, the exposure is huge for them. And what they're interested in is compliance, that things are going the right way. So when we talk about information that the employer has, many times the employer understands significance and the approximate amount of potential exposure for it. So if they're interested in a global settlement, that tells me something different too. But certainly a lot of this may not be coming as a surprise for at least one of the parties involved in this kind of action, in the PAGA actions.
Young, I think you had some comments to add.
Really quickly, for the audiences, people who know this will also know, and if you haven't had an experience in a situation like this, I want to let you know that this rather really happens all the time, because once the settlement amount, the dollar amount is decided, it is the defendant's wish usually to want to include as much as 1542 as possible for all possible causes of action, as just Jackie mentioned. But the court usually is very sensitive about approving the overbroad release. And that's the reason why the motion for preliminary approval action it is usually rejected almost all the time for the same reason and very frequently. As to the objectors, just my little comment, with all due respect, they object no matter what. They will object no matter how you well explain about the discovery conducted, and then the judge eventually dismiss their objections. They will just go ahead and object and then go ahead and file an appeal to get the little bit of a piece out of your pie. So that's that. Just regardless, this is all the more reason why you would want to be well prepared for the fuller analysis issues in your declaration in MPA.
Thank you. We have an interesting incident that Jackie faced involving a policy limits demand. Jackie, will you lead on that?
Absolutely, absolutely. If this was a wrongful termination based on medical condition disability case, and that was filed against our client by a former administrative clerk. We have been litigating this for a bit, and the attorneys on both sides decided that we needed perhaps some early mediation, that we could pretty much see each other's damages, potential damages, and it would just be in the best interest of clients to do so. After a lengthy conversation, we were able to get a mediator who could help us immediately. We had also talked roughly about damages. I prepared a very lengthy report to the client as well as the insurance carrier. This was a case where insurance was involved. And in doing my reports, I always include a full legal analysis as well as a good, well-established range that I thought, based on previous cases that have been litigated throughout LA County, what I could see as a reasonable settlement range. Now, that report is turned into not only the client, but also the carrier and who is usually the adjuster on the first level. But based on the amount of money that's being asked for to settle the matter, the adjuster may have to send it up a chain of command. So I don't know how many layers she or he had to send that request up, but it took about 2 or 3 weeks to finally get the authority to settle the case for this range. So we went into mediation with this range in mind. Mediation started out quite nicely. Everybody was introduced and happy to be at mediation. And then our mediator went into the plaintiff's room and was immediately told by the plaintiff's counsel, that he wanted policy limits, $1 million. Well, that was far out of the range of anything we had previously discussed. It didn't reflect the kind of evidence that we had. And so mediator came back to me and said, look, we got a problem. You know, you tell me this, and this is what you say you may be able to settle for. But in fact, this plaintiff wants $1 million. At the same time she's delivering this message to me, I'm getting a letter via email say from the plaintiff's attorney with a policy limits demand letter. Frankly, this is not a letter you deliver in mediation. It's a letter you should send defense counsel well before we get to mediation. Needless to say, there was no way we were going to settle the case at that juncture in the case for $1 million for the policy limits. So the mediation ended. Obviously, it was a waste of time for everybody, and we continued with the litigation of that case.
I think what's happening in that situation is that plaintiffs fear giving away too much information. They fear that they will be creating something that they can't come back from later on. It's counterintuitive for plaintiffs' counsel to give a whole lot of information. It's counter to the way most cases are litigated. But in a policy limits demand situation, the burden is on the plaintiff to make the case, to create such risk in the mind of the carrier that there's a real possibility that there's going to be a policy limits met. So the idea of making such a demand on the eve of the mediation or during the mediation speaks to the potential of the case ending, just as Jackie indicated that it would. The carrier needs time to assess. And just to give you all an idea of what I have seen happen is that a plaintiff might even, on a large case, submit to the carrier a day in the life of the mediator to establish support for liability and damages. So there's a lot of information that has to be brought to the carriers well ahead of time so that that assessment can be made. So there's some elements that should be in that policy limits demand. And there's an article in your materials that I wrote for the Advocate magazine. Kala has given us permission to reprint it. And it sets out those elements of a policy limits demand. And the plaintiff has the burden to show that liability is clear, that damages will exceed the policy, and not just based on allegations, but actual evidence that's proffered. The demand must be unequivocal. It must cover all plaintiffs, all claimants, and all claims, as well as all insureds. The demand should take responsibility for any outstanding liens that the plaintiff has, and should include a response deadline, as well as information as to how the defense should go about requesting additional time, should additional time be needed to do that due diligence. So that's an outline of what wasn't presented to Jackie in that short policy limits demand mediation, and certainly speaks to why the whole mediation tanked. I'd like to move on to slide 8 now, Jackie. Surprise. Client is too busy to attend the mediation. So it's in the beginning of the mediation, and I enter plaintiff's room, and I know that there's no plaintiff there. And I'm told by the attorney that the plaintiff is too busy to participate. And my response is at 10:10 in the morning, I'm finding out about this now because, and of course, my next question is, what does the other side know? So in the course of speaking with plaintiff's counsel, I learned that the plaintiff is incarcerated. I learned some of the details of the incarceration, but I'm told I can disclose only the fact of incarceration and nothing more. So I go into the defense room And the defense had done its due diligence in terms of the incarceration, had the rap sheet, knew exactly what was going on historically as well as for this current conviction, and basically was okay with going on with the mediation. What I had done in the plaintiff's room when the counsel announced that to me is I said, send me immediately an email that sets out your authority, which was represented to me to be the authority to negotiate and to settle the matter on behalf of his client. So I did receive that. And my concern is durability of any agreement that might be reached. How's that going to work? Well, in this case, I felt I had dodged a bullet. Defense counsel wanted to move forward with the mediation. The matter gets settled. But I couldn't help but wonder, okay, so what if the other side didn't want to move forward or didn't even know of the incarceration? And like every other case, a mediator is going to try to find a workaround to figure out how to keep the ball in the air to get us to the finish line. Ultimately, if there was no agreement as to how to handle that circumstance, the mediation would have to end. Jackie, you had a thought about how some employers would react to this sort of a situation?
Right, yes. I think a lot of employers, even if they know, and especially if they know that the plaintiff is incarcerated, and many times we do already, the fact that they showed up for mediation, they spent the money and the time to go there, is important to understand. And the reason is that you've got to understand the employer's mindset. Once we get a controversy and we're in litigation and we're going to mediation, it means the employer really wants to end the controversy, end the lawsuit or the claim, and get a settlement done. So for the defense counsel, it means this is another tool. The incarceration is another tool we can use to negotiate what we think the value of the case is, given the situation of incarceration. But the ultimate goal of any employer is really to get it settled. If we're going to mediation, we're going to spend the money and time in that activity. We want to settle it for good.
Young, I think you had an observation.
Yeah, just really short. This was considered as a sanction of conduct at the mandatory settlement conference by the court, the one that we have in Spring Street Courthouse in LA. If you don't bring your client for the mediation, if the other side immediately go ahead and try to move for sanctions. Not me, that happened, I saw. But this is obviously a malpractice if the plaintiff's counsel didn't bother to let his client know that there is a mediation happening. So let's go. Surprisingly, and you're not going to believe this, there are many people like that out there, unbelievably, that they just go to the mediation, settle the matter, and then have the client sign it. It raises multiple ethical issues, but the commonsensical biggest problem that I can immediately see is how can you bring a settlement agreement with a dollar amount unknown to your client, all the terms unknown to your client, and have a meeting with your client later on, sign this, because I got you this much of money. It's just a ridiculous situation too.
Well, the case to which I was referring was a private matter, not court connected. And I agree with you. The plaintiff's participation is mandatory, for which there would be sanctions. In this particular situation, though, people agreed to move forward in this circumstance. And obviously, there would be necessity to confer with the client to explain, perhaps, well, I was going to say throughout the day, but probably not if the person's incarcerated, but certainly explain at the end what had happened and the basis for the amount of money being reached. Unfortunately, I've seen this happen lately where counsel agree that their clients aren't going to show up. And that's bothersome to me because after all, it is the client's case and so forth. But my basic default position is after encouraging the participation of the clients, I defer to them. If they decide that they want to move forward under those circumstances, that's okay. And I will go ahead and proceed with the mediation. In this particular situation, and many these days, the actual drafting of the settlement agreement happens later, be it a week later, a month later, whatever it might be. So there's adequate time to sit down and go over those terms at that point. Where I see the absence of the party in the mediation as a problem is if one of those situations where there might be fear that the party is going to change his or her mind or not be around for the settlement. So I understand the issues, and it's a dicey situation, but I don't know that it's not one that doesn't happen more frequently than we'd like. That's my thought about it. Young, let's move into the next topic if we can. The next slide, Katie. You had an interesting experience with your client and your client's eloquence, as we say.
Yes, I think this is though happens all the time, and then everyone in this Zoom window right now will think of one situation where your client became completely eloquent, or for that same matter, completely diseloquent. Before the mediation, you prep your client, sharing a lot of documents, talk about a lot of things that we alleged and then how we have litigated the case. It seems like client understands what you are saying. You go to the mediation, and the mediator starts asking questions directly. And your client goes either way. One, eloquent, goes on and on talking, never stops, and talk about some which is completely different from what you shared and what you have known throughout the discovery. Started talking about all of these things, confusing the mediator and then making you frustrated and embarrassed. The other one is more like a not eloquent situation when he has to be or she has to be. Mediator asks, so after the termination, how did you feel? I was all right. I'm cool because I'm a very tough man. That really doesn't help for your case. So, but how many times we actually saw a situation like that? So that is a difficult situation, obviously. I try to bring this example because Lynne really wanted a real, like a live example of what happens in the mediation. I think this happens the most frequently, at least in my history. What I can do is I can talk to the client when the mediator is out to talk to him. This is very different from our understanding. Are you sure about this? Usually they say, oh, did I say that? Oh, I didn't mean to say that. And then once the mediator comes back, you have to correct it, repair the situation. And if that does not work, and then if the client's narration, the responses to the mediators actually turned out to be true, which is something that you never knew before, then for your plaintiff's attorneys, that's all the more reason to settle the matter at then mediation. The good way to do so is work with the mediator. Try to minimize the exposure of the plaintiff's confession so that it can help your position to negotiate. But at a certain point, there are certain things that has to be disclosed to the other side. So if everything what the client said is true, not just an inadvertent comments, then I guess your case value just got plummeted. And again, all the more reason that you want to settle there.
My thoughts based on what you were just saying, Young, is that a mediator would want to probe a statement such as I'm okay. And there might be a lot of content under there that just wasn't brought out. So that would be my first thought based on what you said. But this is also an example of why some counsel would instruct their clients not to speak directly to the mediator for fear of losing control in the way that you've described. So I don't recommend muzzling clients. I think it's clear that clients feel more, when they feel more involved, there's a better outcome. They feel better about the outcome. So I don't recommend decreasing the participation. I think there's a basis upon which a statement that's statements that are contradictory to one another can be used to change the expectations of the client in terms of the financial settlement amount. And I think in the end, as a practical matter, as you've indicated, Young, that you'd rather know sooner than later, you know, if you've got an issue, a question, an important aspect of the case. Okay, so next slide, please. So this is a pretty easy situation in terms of the factual background. Defense counsel in this case said to me, hey, you know, if you settle this one, I'll bring you more cases. So I have to say I was pretty stunned with that comment. My response was, well, that's not appropriate, and let's concentrate on today's case. So what was surprising to me about this is how that impacted me. I felt that I was dealing with some dirty shenanigans. Maybe, you know, at best the person didn't understand the process, but I doubt that. And I was surprised that how I was inclined to do probably just the opposite of what this attorney was trying to do, which is to get me to lean toward his analysis or in his client's favor. Was he trying to knock me off my game? Should I, you know, did he think I'd take a bite of that apple? I mean, I don't know what was going on, but it sort of left me feeling that that was really a brazen sort of comment that he made, and I was knocked off my balance. So I want to point out that there's a document called the Model Standards of Conduct for Mediators, which is in your materials. It's an old document. It was prepared in 1994 and again revised in 2005. The mediators who are in the room are probably aware of this. It was prepared by the American Arbitration Association, the ABA, and another organization. And these standards are largely historical and advisory, but it does begin to give you an overview of the principles that underlie mediation. And one of them is neutrality. So if I felt that I was so knocked off my center that I couldn't conduct the mediation competently going forward, then it would really be my obligation to end the process. That wasn't the case, but the fairness and impartiality and neutrality are cornerstones to the process, and this document ends up speaking to those concepts. So I was truly shocked by that situation. Jackie, I think you have some comments.
Well, my approach to all of this is that anytime we're doing something in the legal setting, in the legal process, we are all duty bound to follow the rules of basic fairness and honesty, while still vigorously advocating for our clients or defending or prosecuting. I mean, but the guiding light for all of us, be it mediators, attorneys, judges, we all need to adhere to fairness and honesty. And I include people who are involved in it as carriers as well, clients as well. So I think that we need to rely on those rules as they apply to everyone in the process. I know that at times there are certain, mediators who are favored by large corporations or something like that in mediation, and that may present a problem for some mediators. But I think, again, where we are forthcoming and honest, we should be able to avoid those kinds of ethical problems. But offering someone to bring more cases, essentially bring money to you, is just fails the fairness and honesty test completely.
Yeah.
Yeah, for the plaintiff's perspective, I want to highlight though how much a mediator / arbitrator can draw line between the cases that they are getting as an arbitrator while wearing the same cap, the other cap as the mediator. Once we initiate the arbitration process with ADR, Judicate West, Jam's signature, the first thing we will get is that arbitrators' previous business relationship with the defense firm. I didn't start my practice overnight. I've been doing this for a while, almost 20 years now. But while we have dealt with that arbitrator, the history of it usually goes from 4 pages to 12 pages. While we receive that particular arbitrator's business dealings, previous business relationship, working relationship with that particular defense firm goes 176 pages. So when that happens, and now you are in the mediation with the same arbitrator, how much of the impartial or the good result out of the mediation can be expected is the question that I want to raise. Well, plaintiffs' bar in LA maintain pretty good record of such occasions, which arbitrator has how many cases with the particular firms. But it is still possible that there are some other attorneys out there who has no such data, just rely on the bio of the arbitrator/mediator and choose one. So that's one other perspective that I want to highlight here.
You both have made an interesting point, talking about disclosure, what the mediator's obligations are for disclosure. And I think that the mediator, whether he or she, the question is whether he or she has an ethical or legal duty to disclose the cases mediated for this particular counsel or party, as arbitrators do. And I think the answer is no. The argument is that mediation is not an adjudicatory process, it's a consensual process, and the mediator is not making an ultimate decision. However, a mediator certainly can have a lot of impact on the course of the mediation and the settlement. So to that end, I used to get calls where people would inquire and say, well, have you ever mediated with this particular party, this particular counsel? And I'd pull up my database and how long ago was that? And how many cases have you had? And I felt that that was due diligence on their part, but I don't get those types of calls anymore. What I really want to emphasize, however, is that the way those types of calls are handled, the response that's made in terms of candor and the forthrightness and the attitude that's conveyed is going to probably make more difference in the end as to whether the mediator is selected for that particular case. I think that the mediator's real currency in a mediation is trustworthiness. And I think by the way that is handled, those questions are handled, the mediator is either going to garner the respect and selection or not. I once had someone say to me, well, I mean, if you're any good, I would have expected that you would have mediated with this particular, client, counsel, whatever it was. So that's my thought on it. Without fairness, without neutrality, without impartiality, really that's a death knell for the attorney's, the mediator's reputation, as well as the growth of the practice. So let's move on to our next topic, which is surprise, more documents after discovery has concluded. And Young, would you start us off on that discussion?
This actually happened in my last mediation with, we're not supposed to tell the names, last mediation. So at the mediation, the mediator brought a document showing to us that I just have this as an exhibit in the defense counsel's mediation brief, which was never produced to us. I immediately asked, because this didn't happen only once, what's the page number on the document? There was no page number. So that's the new document. Although this case, we didn't have the discovery cutoff yet, but the additional document produced at the mediation was, for example, a severance agreement giving my client $50,000 and 1542 entire claims. Then your case is practically dead right there. Situation like that, you have to, of course, confirm with your client because your client has to be there at the mediation. And once that happens, because practically your case is dead, there are several things that I have done in the past out of this very, very annoying situation. Happens a lot more in the individual case. I actually walked out of the mediation and then engaged in further discovery. Despite the suggestion of the mediator, let's go ahead and work on this. But I'm sure you will always have to make a decision dependent upon what kind of damaging or dispositive evidence that you had no chance to see before the mediation is presented at the mediation. And also it's even more problematic if the discovery cutoff was already done. Then you just have to file a motion to extend it or report it to the judge to discuss what has to happen next.
I just had this happen to me about a week ago. It was noon the day before the mediation, and I got a call that some new evidence surfaced. It was going to change the entire trajectory of the mediation. Fortunately, counsel had a professional relationship, worked together, stick to a new date. I don't know that it probably wasn't after discovery, so it's a bit of a change circumstances. But my point is, it's important for counsel to lay the groundwork for those types of situations that may appear later. Jackie, you have a thought about walking out of a mediation?
Well, especially if this is at the point where you're after discovery cutoff. I mean, this would be sanctionable behavior on the part of the attorney not to have provided this document. And let's face it, most of the time you're in mediation, it's after discovery cutoff. So I'd inquire as to exactly what prevented them from producing the document, even if it's the night before mediation. Give us everything so we are prepared. Don't surprise us in mediation. It's simply not fair. And frankly, I'm inclined to go ask for sanctions or perhaps get a stipulation or an order to continue the trial date so we can continue discovery and we can get to the bottom of it. But this is really poor behavior on the part of the attorney. They could have done better, had a better explanation for why the discovery wasn't provided in time, at least for the mediation, if not before the discovery cutoff.
Thank you. We're going to move on to our last topic. Sliding the next slide, please. Thank you. We have just about a minute or so. After a day-long mediation in which the settlement agreement was all but executed, the mediator learns in the defense caucus room of the plan of the defendant to file for bankruptcy a few days later, early the following week. So the mediator was really upset about this. It was felt lied to, felt that the whole process had been thwarted, and was quite upset about it. This was not my case. I know that the case ultimately did resolve, but wasn't privy to what happened during those caucuses. I do know that there have been times when I've heard a lot of comments and threats, I would say, about bankruptcy. And I don't know what happened, and maybe it was a threat, maybe it was real, who knows what. But Jackie, you have some thoughts about that, please, your perspective?
Well, I certainly have had settlements or negotiations where the client was thinking about it or actually on the verge of filing bankruptcy. And so I would say that there's a possibility here of getting a settlement because the defense wouldn't be in that room paying money for mediation unless they were seeking settlement for whatever reason. So I would pursue trying to get a settlement, getting over the anxiety of hearing about bankruptcy at the last minute and see what you can work out. Because in the end, in terms of what plaintiff may get, it may be better to get something less now than to end up in line at bankruptcy court. So that's my advice.
That very well may have been the discussion. As I said, I don't know. Anyway, I think we're at the top of the hour. And I want to thank you all for jumping into the rabbit holes with us. We hope we have left you with some thoughts about what you might do or not do in the future should you face one of these or another rabbit hole. And I want to thank my co-panelists for their commitment to this program.
Yes, thank you. Thank you to all three of our speakers this afternoon, and thank you to everybody for joining us on your lunch break today.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.